Mastering trial preparation, essential steps for success. Hey everybody, I'm Joel Williams. This is Chase Elleby from Williams Elleby. We're personal injury lawyers in Kennesaw, Georgia. And today we want to go over those steps that you need to take in order to be successful at trial and give yourself the best chance to win.
Yeah, so the idea with all of our videos are to educate, I guess, the population, right? The masses through YouTube. And some of those videos are geared more towards just everyday folks who have no idea, don't practice law, don't have a law degree. Some videos are geared more towards, new lawyers or people in law school, and other videos are a little more complex, and kind of get into the weeds of certain subjects that we see on a regular basis. I would say this video is probably geared more towards law students or people like, starting out on the personal injury side, or personal injury lawyers, just try to get an idea of things they need to start thinking of when preparing a case for trial.
So when and where do you start preparing for trial, Chase?
At the very beginning. I mean, I'm preparing for trial, at least thinking about trial, while I'm talking to a potential client, right? Even before we sign them up, once we sign them up, and definitely, you're thinking about trial as soon as you file that lawsuit. There's no point in filing a lawsuit, drafting the complaint, if you're not ready to go to trial. So it starts at the very, very beginning, and I guess if you want to put a specific start on it, it's definitely when you file the complaint, right? The complaint includes things like what the acts of negligence that you're alleging against the at-fault person or entity, the venue where you're going to file that lawsuit, who all the parties are going to be, whether it's a person, a corporation, or both. So you're already starting to think about those things from the very beginning.
Yeah, and it's not like you file a lawsuit and then you immediately go to trial, right?
Correct.
So there's a ton of videos we've got out about this, but essentially what I think Chase is trying to say is from the time that you file a lawsuit, and every step from that moment up until the time of trial should be in preparation for two things. Primarily, what's going to happen if you have to go to trial,
right.
And number two, to try and get the case resolved short of trial, because in our experience, if you prepare for trial, then you're more likely to get a reasonable settlement offer, or if you're the defense lawyer in a case, you're more likely to discover information that means your client won't have to pay as much if you prepare like you're getting ready for trial.
That's right. Yeah.
Yep. Okay, so you file the lawsuit, you go through this whole discovery process where you send written documents or written questions, you get answers to written questions, you send requests for documents, you get documents, you take depositions, which are out of court testimony that people have to give under oath. You do all these things, and then you get to the point to where you can't get the case settled. You've done everything you can, but it's time for trial. And you've got 3 weeks, 4 weeks, and you're going to be in a courtroom trying your case. So there's a certain amount of things, or there's a bunch of different things that you really need to think about and do well in advance of walking into that courtroom to prepare yourself for success, especially in personal injury cases, which is what we're used to, but I'm sure it applies to all different types of cases. But when you're thinking about first steps, when you know you're going to trial, Chase, what are you thinking about? What are the first things you're going to start working on?
Yeah, so the first things that I'm going to start working on is, one, I'm going to refresh my recollection of that file, right? I'm going to go through all the discovery, all the depositions, all the written questions, all the documents and things like that have been produced or discovered throughout that discovery phase, right, while the case is in litigation, and then become familiar with that, right? And as you're reading and going over all this stuff, going over medical records, looking at, or reviewing doctors' depositions and things like that, you start to develop a theme. And a theme is very important for your trial, because when you're trying a case, and Joel, I know we'll probably get into this here in a little bit, but as the lawyers, you sort of get into the weeds of like the real legal and the nuanced things. But in reality, when you're trying a case, you're speaking to 12 regular folks. So developing a theme that can relate to 12 regular folks is very, very important. So that's, when you get to that point where you're in trial prep mode, it's going over the discovery, start thinking about the theme and how you're going to present that case.
Yeah, and the reason you want to go over the discovery is all of this work you did to get to this point, it'll help you remember, okay, what is Johnny going to say? Like, what's his testimony going to be? What did he say in his deposition? What's the defendant going to say during her deposition? Or what did she say during her deposition? Because that's likely going to be what she says on the stand. Yep. If she says something different, she's going to be in trouble.
Right.
And then you kind of get all that refreshed in your mind, and then you start looking at, all right, what documents am I going to be likely to use at trial, and which documents may I use, but it's not really likely, right? So you get all that stuff organized. Sometimes things have to be redacted, because of evidence rules. You have to take stuff out of documents, especially things like social security numbers that may be in medical records, or dates of birth, or insurance information. Any of that kind of stuff you got to take out. In most states, because it's just not something that's admissible into evidence.
Right.
So you prepare your exhibits, get them organized and ready. You have all your witnesses in mind, and what's the next thing?
So you brought up a good point, right? Admissible as evidence, right? So in discovery, it's very wide open. You can learn things that might not necessarily be brought into trial. So when we're going over the discovery documents, reading the depositions, looking at the documents and things like that, you have to look at what's going to be admissible as evidence, and that leads us to the next step, which are pretrial motions, right? So a lot of times we will file what are called motions in limine, which are motions to exclude certain things from trial, right? I'll give you an example for like a car wreck case, right? A standard car wreck case. We might want to exclude the fact that our client had been in, a car wreck 10 years ago, because we don't think it's relevant. We think it's outside the scope of what that trial should be focusing on. So we have to file a motion and ask the court to exclude that. So that's just one example of a pretrial motion, but those are the sort of things that we have to start thinking about and preparing for, and then filing with the court.
Yep, and you can rest assured that in most situations your opponent is going to be doing the same thing.
Exactly. Yep.
And those motions in limine too, sometimes they are to have things admitted into evidence. They're most commonly used to exclude information or documents, but they can be used if you want to be proactive about something, or if there's something you're worried about, to ask the court to say, hey, this is going to be admitted into evidence, just so you know as you prepare for trial. So you've got your witnesses together, you've got your documents together, you've got your motions filed. There's also in most courts what we call a pretrial order. It's a consolidated version of all the facts, all the witnesses, all the legal contentions, things that the jury may have to be qualified over, and each side has to list all that stuff out. But at least in all Georgia personal injury cases that go to trial, there's going to be a pretrial order entered before you ever get in.
For the most part. There's very, very rare exceptions where some courts don't necessarily require a pretrial order, but for the most part, and especially in most metro Atlanta counties rather, you will have to have a consolidated pretrial order that is filed with the court. And I just think of it as kind of like a roadmap to everything that could possibly happen at trial.
Yep.
So,
and both sides will need to prepare that and consolidate it and then present it to the judge to be signed. And like Chase said, that pretrial order is going to control what can come in and what can't come in, at least the major issues at trial, and what the main things that the jury needs to be qualified for, just so you can pick a jury. Right. But speaking of picking a jury, another thing that you need to start preparing for is jury selection, what we also call voir dire. And that's where the attorneys get up. If you've ever been called to jury duty before, if you've gone in the courtroom, one side, whether it's the prosecutor or the plaintiff's attorney, will get up and ask a bunch of questions that may be relevant to the case at hand to see how you feel about it, what your experiences are. Do you have any biases or prejudices, or can you be a fair jury? So the plaintiff or the prosecutor will ask their questions, and then the defense will ask their questions. But you have to go ahead and prepare ahead of time, generally, not down to every word, but generally what questions are you going to ask and what topics are you going to cover, so that you'll have a good shot of identifying any jurors that may be bad for you or that have preconceived notions that would lead them to lean one way or the other before the evidence starts to come in at trial.
Yeah, and that's a good way you can sort of weave in your theme of the case and at the voir dire stage, where you're asking those preliminary questions of the jury to try to, I guess the common assumption is that you get to pick, us as the lawyers get to pick the jurors, but we don't pick them. We just can strike the ones that we don't think will be helpful, right? But it's during that time where you can sort of weave that theme in, weave the theme into what you're going to be presenting to the jury, and sort of feel out, how they're, receiving that, if they're going to be biased or not. So,
yeah.
All right. So the next thing, once you've kind of done all that, I'm always looking towards, or my next step is going to be preparing the witnesses for trial. Okay, and that's a big thing, right? So
often overlooked, but super
for
important.
sure. It's huge, because you got to understand, when you're litigating these cases and you're in the discovery phase, depositions are sometimes taken 2 years before you actually get to trial. And by that I mean my client who, we'll just keep it a simple car wreck case. We might have filed the lawsuit, say January 1 of 2020, just for an easy date. They might have their deposition taken March 15th of 2020. Well, we might not get to trial until July of 2023. It could be years and years since their deposition. And so it's very, very important that when you're preparing the witnesses, the first thing I do is say, hey, here's your deposition. Read it. This is everything you said and you swore to 2 years ago about what happened, how this impacted you. So that's the first thing I do. And then we sit down and start talking about what potentially the cross-examination questions are going to be. What's the other side going to beat you up about that you need to prepare to answer, right? So it's very important to prepare those witnesses to make sure that they're, one, aware of what the other side's going to ask, but also, two, that they're aware of what their testimony said. Because like Joel alluded to earlier, if, in your deposition you said, no, the light was green, or, said, no, the light was yellow, then you get up and say, no, absolutely, the light was green at trial. Well, the defense attorney is going to rake you over the coals with that because you swore in your deposition 2 years ago that you said this and now you're saying that. And so your credibility is completely shot. So absolutely preparing the witnesses is key.
Yeah. And there's a big difference, in my opinion, from preparing a witness and telling a witness what to say.
Oh, 100%. Yeah.
No lawyer should ever tell a witness what to say or encourage the witness to say anything other than what's the truth.
Right.
But there is a way to prepare a witness for example, what topics are you going to cover with them? If you're calling them in your case in chief, what type of questions might you ask them? What questions, like you said, should they anticipate the other side asking them? So they are aware and at least thinking about what they're going to face when they walk in that courtroom. And if you're really on top of it, it might be a good idea to bring the witness to the courtroom and put them in the witness chair so they can see where they're going to be and what it looks like, especially if they've never testified in court before, just to be comfortable with the room and show them where you're going to stand, where the other lawyer may stand, where the judge will be, where the jury will be, just so that they're comfortable, because no matter what you do, nerves are going to be involved, and anything you can do to at least prepare them for what they're about to walk into, short of telling them what to say or doing something unethical like that, then you absolutely should do it. But speaking of preparing, and also if there's witnesses that don't want to cooperate, you need to make sure you send them subpoenas and have them properly served with a subpoena so that they have to be at trial when you say they need to be there.
Yeah, and just to kind of hit on that briefly, most of the time your witnesses, if they're your witnesses, you just ask them, they'll show up, right? Because they're ready to go. But if you have those witnesses, like Joel said, that don't want to show up, you get a subpoena from the court or the clerk's office, literally fill out to who it's going to be sent to, the date that they need to be there, the time, the location, all that, and they're compelled to be there. So, they don't necessarily have to show up, but it's a very, very strong incentive to show up because there's repercussions if you don't comply with the subpoena. So yeah, you definitely get them subpoenaed.
Yep, exactly. Okay, so other things that are good to prepare in advance of trial is after voir dire, the next thing that happens, usually the judge will give some preliminary instructions after the jury is sworn in. But then the very next thing that happens after that is opening statements. Mm-hmm. So an opening statement is where the attorney or the party, if they're an unrepresented, lay out to the jury what they believe the evidence is going to show, what witnesses are going to show. They dive deeper into the theme of the case. Mm-hmm. And it's not supposed to be a time to argue, but it's supposed to be a time to present what you believe the evidence is going to show and kind of give the jury a Cliff Notes version of what you intend to prove.
Yep.
So prepare that ahead of time. It's rarely a good idea to just write it out and read it like you're reading out of a book, but you can write it out if you want to. I don't recommend reading it at trial, but at least have an outline there so that you can cover everything you need to cover before you start calling witnesses.
Yeah, and the benefit of an opening statement is that you can prepare for that a little more specifically prior to actual trial because you sort of already know what you're going to say. Mm-hmm. So it's a little bit easier to have, say, 90% of the content that you want in the opening ready to go. Because again, not a lot's going to change from the time you select a jury to when you come to your opening. But the closing statement's different, right, Joel? So the closing statements where at the end of the trial, you get up and you basically lay it all out for the jury. Now you can have your outline based on what you think the evidence is going to show, but so many things happen at trial. Sometimes evidence is comes in that you didn't anticipate. Sometimes evidence is left out that you did anticipate. So you have to be a lot more agile, mobile, and hostile when it comes to preparing that close. But you definitely want to prepare it to where you sort of have an idea of what you're going to say, but also be extremely flexible and be ready to be flexible, I think is important too with the closing argument when you get up there and argue.
Yeah.
So.
And if you're watching this and you're an attorney and if you've never given an open statement before, if you're kind of new to the process, one thing that I used to do that helped me a lot was I would set a camcorder back when we did I just age myself?
I said camcorder, like what in
I'd put a video
world is a
camera,
camcorder?
put a video camera up on the fireplace.
Got a VHS tape cassette out there.
I'm not that old. I would put the camera up on the fireplace mantle and practice giving my opening statement, videotape myself and watch myself, because I would see little tics that I had, or I would listen to it and I'd go, well, that doesn't sound very convincing, or that's not very persuasive, or that's really good, I need to hold on to that.
Right.
And it gives you a chance to kind of assess yourself and things that you're doing well and things that you might be able to improve upon when you get to trial. Another thing is that so generally the way the trial goes is you have opening statements, then the plaintiff or the prosecutor is going to call all of their witnesses, and then they're going to rest before the defense presents their evidence. In between that time, the defense is likely to make a motion to have the case thrown out. And so if there's when you're presenting your evidence, you want to make sure you know all the legal elements that you have to prove and that you have to present evidence for, so that the defense is not successful with that motion. So you kind of have to try to anticipate those motions. It helps to have some experience and be a lawyer when that stuff comes around, so you're not blindsided by it. But then after that, the defense is going to present their evidence, their case, and then you're going to move into the closing arguments that Chase was talking about. Mm-hmm. After closing arguments, there's post-trial motions. There can be all kinds of post-trial motions that we're going to skip over that because we're talking about preparing for trial, not post-trial motions. But in between all that time, you have the judge is going to take, after closing arguments, sometimes before closing arguments, the judge is going to instruct the jury on what the law is. So usually the way that happens is if you're in federal court, most state courts have pattern jury charges, and ahead of trial, the lawyers will work out what they propose that the judge uses as far as these pattern charges go, and then they may present unique charges on areas of the law that the pattern charges don't cover. But you have a charge conference. Once all the evidence is in, the judge will excuse the jury for a minute, and then the judge will go over all of the proposed charges with the parties, right? So way before trial ever starts, you have to get your proposed charges together, and then if you have any that aren't pattern charges, you have to be ready to defend those charges in front of the judge and convince the judge why he or she should charge or instruct the jury as you want them to do so. So that's another thing that you have to prepare for well in advance of trial. Other little things, so a few miscellaneous.
Well, yeah, we talked about evidence as far as witnesses are concerned.
Mm-hmm.
Of course, so you got to prepare evidence as far as documents are concerned. You got to redact information. You got to redact, social security numbers, date of birth, things like that. If there's, a bunch of medical records that you're going to be admitting into evidence, you got to redact any mention of health insurance or anything that says car insurance or anything like that, because as most folks know, when you're going to trial, there's insurance involved always. But
if it's a civil case,
if it's a civil case, yeah, but
if it's a personal injury case, there's going to be medical records involved.
Right, exactly. So you got to redact those types of things, because once you admit those documents into evidence, they go back with the jury, and the jury can look over them and things like that when they're trying to come up with their verdict. So you got to prepare those as well. So that's kind of something we skipped over, but that definitely takes a lot of time.
Yeah, good point. And then lots of times the little things will be overlooked, right? So technology in the courtroom. You got to make sure that any computers, any iPads.
Know what the technology is. You can go test it out, right?
And I'm going to tell you.
Have a backup for a backup.
It's different for every courtroom, because if you're in a major metropolitan city, Usually it's going to be, not that anything in court is cutting edge, but it's going to be more advanced than
you can plug in your computer and you're probably going to get a projection on the screen. That's
exactly.
That's what you, at a minimum, that's what you can you can count on. But
whereas
in rural county,
you may have to bring your own screen. You might have to bring your own projector, your own TV, your own cord.
You might get an overhead projector if you're lucky, but that's about it.
Exactly. So anticipate technology issues. People laugh at me sometimes, but I will literally take a fishing tackle box and I'll have things that range from highlighters to pens to staplers to markers to Tylenol and ibuprofen if I get a headache during trial. You have to think of everything to make sure that you're not caught unprepared at trial. You know, if you've got a headache and you're sitting there miserable or whatever, just make sure you have those things.
Know your local rules.
Yeah.
Local rules are important.
And even within like a certain county, different judges prefer to do things different ways sometimes because the law lots of times gives judges tons of discretion on how they want to run it.
Yeah, and if you're a new lawyer, don't be afraid to, contact the judge's staff attorney or, the judge's office. I mean, most of the time they're super happy to answer any questions, but even if you think it's a silly question, just call and ask. I mean, they'll be more than willing to help, so.
Oh yeah, and we did that just a few weeks ago for an upcoming trial. I just emailed the judge's staff attorney and said, hey, I got a few questions about how this judge likes to do this. And then so what we did is we arranged for a short video conference between defense counsel, me, and the judge's staff attorney to make sure everybody knows exactly how the judge wants the trial to proceed and how to handle that specific area of the trial. Other things are travel arrangements. If you're going out of town, make sure you have a hotel reserved for a sufficient amount of days. Make sure you got your plane tickets booked if that's involved. If you're in a small town, make sure you got cell service there. I started practicing in a town with 6,000 people in it, and if somebody came there with AT&T, they didn't have cell service. And that could be a problem if you're trying to give witnesses a heads up, hey, we're going to need you in 30 minutes or whatever. So all those little things, just make sure you have it. Attorneys, sometimes it's good if there's not good internet service or cell service to have books, like your evidence books, so you have a hard copy of a quick reference. You can go on Westlaw or Lexis or whatever and print out things that you need if you don't want to order the books. But just try to think of anything and everything that you could need and be over-inclusive rather than under-inclusive, because you would rather, it's the old saying, you'd rather
have more and need less.
You'd rather have it and not need it, than need it and not have it. So anything else we need to talk about as far as getting ready for trial? No,
I think we pretty much hit the highlights. It's extremely time intensive, so even for the small cases we spend a lot of time preparing for trial. So just go ahead and anticipate what you think you're going to need, as far as time is concerned, and double it, right? And so that way you don't feel rushed and all that. But no, I think we pretty much hit the highlights of what we do as personal injury lawyers to try to get ready for trial. So
preparing for trial takes 4 or 5 times longer than actually trying the case usually. So just anticipate that and you'll be okay. But I think that's it. So if this video has been helpful to you, we'd appreciate you giving us a thumbs up, hitting that subscribe button. Otherwise, we will see you next week for another personal injury video.